The attorney then continued to communicate directly with the other party, and it got quite hostile and caused unneeded hostility in the case. So pass on that information to the attorney because it's quite important, and it's a way to protect the interests of all the parties involved, and to not appear to put undue influence on another party that you're contacting them directly. Okay, those are the specific rules that our office has seen that paralegals are involved in. Are there questions on that? Okay, now we're going to get into this fun part. So, the unauthorized practice of law, and this woman over here touched on it, happens more than you'd think with paralegals and staff members. Sometimes just maliciously because they just don't care, and sometimes because they honestly don't know that they are crossing a line, and that can implicate the attorney because it means the attorney perhaps did not supervise them or train them well enough. So, first I want to start Rule 14802 in this beautiful book, the rules governing the Utah State Bar, outlines what the practice of law is. And basically says if you are not an active licensed member of the bar in good standing, you can't practice law. And then says practice of law is the representation of the interests of another person by informing, counseling, advising, assisting, advocating for, or drafting documents for that person by applying the law and associated legal principles to that person's facts and circumstances. So don't talk to them about the law and their specific facts and circumstances because that becomes the practice of law. If they start asking you for information about what could happen in a case and you respond like she said, well, in most cases this is what happens, that is borderline and it depends on everything, so I'm not going to say whether that's the practice of law, but it can be borderline because if you start talking about, well, in your case, I think this might happen because in the past this has happened, that is not appropriate at all. The rule recently, just this year, included work done by licensed paralegal practitioners as authorized work. And I want to briefly touch on that. I don't know how many of you are involved in that or anything like that. There's a whole new section of rules about the rules of professional conduct basically for licensed paralegal practitioners. And they follow quite closely the rule of professional conduct for attorneys. There's also standards and discipline rules for them as well. And they are authorized to work within limited fields after you take a test and become licensed. So if that is where you are operating in, then you are authorized to practice law, but that's neither here nor there. Then it goes through an entire list of work by non-lawyers, whether or not it constitutes a practice of law that is authorized, and I'm not going to read all that, but it involves if you have court forms and you're providing clerical assistance, if you're a healthcare worker and you're helping someone fill out an advanced care directive, representing in small claims without compensation but with court approval, being a mediator, that type of thing. It also says, the third one down, I don't have a pointer, but provide clerical assistance in filling out court forms. That is something I believe a lot of paralegals do, is they might help a client clerically fill out forms. As long as you're not providing information about their particular circumstance and the law. It happens a lot in bankruptcy because that's a very form-driven area of law where the attorney will have the paralegal fill out forms based on information from the client. And I've seen probably 2 or 3 just in my time in the office that have turned into UPL complaints because the paralegal has crossed the line in talking to the client. So the actual rule of professional conduct that an attorney can be implicated in is Rule 5.5. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession or assist another in doing so. So if they're found to have assisted their paralegal in practicing law by ratifying it, by knowing about it, by providing them the means by which they can practice law, they can get in trouble. That's such a high school way to say it. They can get in trouble. They can be found to have violated the rules. So your best practice is to understand what that line is and to have conversations with your attorneys about what is and what is not appropriate. This case, that's a very vague summarization of the case. There were numerous cases on this particular attorney involving numerous rules, including UPL allegations. The staff were the liaisons with the clients and were the ones talking to the clients about what to do in this particular field of law and how to continue forward. And there were emails back and forth. This staff member just spouting off about this field of law, and the attorney was implicated. Okay, are there questions about UPL, the unauthorized practice of law concerns? Okay, I have to slow down or you're gonna have to talk more. Okay, so let's get a little practical. So these are some of the traditional tasks a lawyer performs. They establish an attorney-client relationship. They're the ones setting fees. They're the ones giving legal advice. They're the ones appearing in court. Do not appear in court as a paralegal and try and pass it off as appropriate, because it's not appropriate at all. And that's happened before. They will go to court, say, I'm the paralegal, it's fine, I have authorization from the attorney, and we just need to continue this case. That's appearing in court on behalf of a client, and it's not appropriate. To be in depositions, to sign pleadings, and numerous other things that lawyers do, but these are the ones that paralegals perhaps can try and get into. And I don't mean to group you. I'm not a paralegal. I've never been a paralegal, so if this is inaccurate in any way, I apologize. This is what I know. Paralegals, you conduct research, draft pleadings and memos, prepare standard forms, act as a liaison between the attorney and client. And I need to stop there because we just spent some time talking about how you can become too comfortable. I think it's natural and necessary, simply because of the workflow, for you to talk to the client and be the one that is perhaps the middle person. But there's a line between becoming the end person and being the middle person. Organize, analyze, and summarize legal documents, file things with the courts, which thank you, because there was a day in our office when the paralegals were out and we had to file something, and it was amazing for us to figure out how to do that. It was very sad, and then shortly afterwards we had a office-wide training on how to file. Administrative, procedural, and scheduling matters. Are there other things that paralegals do you feel like you do that attorneys can't do, or attorneys don't do? Yeah.
I believe that it's correct to conduct an estate planning signing with just a paralegal.
Mm-hmm.
That's true, because as long as they don't ask questions, as long as they come in and they're ready to sign and they don't start asking questions.
Yes, and in fact,
Sounds
where
really
is it?
a little on the brink.
No, there's it's probably in one of my next slides. But that is when it's executing estate planning documents only, with the attorney permission and things like that, when it's not talking about the substance of those things, I do believe it is appropriate.
Okay. I think so too, but
I wrote it down somewhere on here, and I
no,
don't
it's
know where
like
it
one
is.
little piece that's carved out.
Yeah. I thought it was in this thing,
That's okay.
but
I see the real estate.
anyway, there is something somewhere that says that.
That one did say something about real estate, is that what you're?
No, she's asking about estate planning. Wills. I
There's something.
wrote it down
about
somewhere.
wills right there.
Did you see it? Okay. It's somewhere.
Right there. It's
Oh.
just about drafting of will or trust documents. There we go.
Yes. Well, advising people about the selection or drafting of will or trust documents, that's what you can't do. It's the execution, however, that is usually okay. So what do you do? These are some of the best practices that I have. So always disclose your status, including a signature block saying that you're a paralegal. When you get a phone call, making it clear what your status is so that there's not confusion. Some of these cases where the entire case management has been turned over to the staff, part of the problem and the reason that complaints came in was that the complainant thought that they were dealing with an attorney. They didn't know until long after that this person was only a paralegal. And it's because that person never made it clear that they were acting as a paralegal. You can give information but don't apply the rules or the law. Use signature blocks. You don't establish attorney-client relationships. We had a case where, trying to make this very hypothetical, give me a second because I just remembered off the top of my head. But we had a case where the attorney sent a paralegal to the potential clients where that potential client was to begin the attorney-client relationship. And that person was not in a position to fully understand what was happening to begin with, signed an agreement, and believed that this paralegal was the attorney. Found out later that the attorney was someone else who was licensed in a couple states and resided in another state, and got quite upset that he was not dealing with the person he thought he was dealing with. Don't set fees. Even if you want more money, you can't set the fees. Don't sign pleadings, and you would be surprised at that even happens. The paralegals will sign pleadings, but just don't sign them. Error on the side of caution. So if you think there might be a problem, talk to the attorney, or just say, I don't feel comfortable doing this, or make it entirely clear what your status is. And then know the rules. Like I said at the beginning, your greatest help for your attorney to keep them out of trouble is for you to know the rules under which they operate. You don't need to babysit them, although sometimes we need hand-holding and babysitting. But if you know their obligations, you can better help them fulfill those obligations and not be a roadblock for them, but can act in your own little stewardship or jurisdiction ethically so that your attorney can act ethically as well. Are there questions? Do you have examples? Because I feel really bad, I got done 10 minutes. Fantastic, okay.
On the setting of fees, I worked in an attorney's office, but I never knew really what was okay and what wasn't. Because they would tell me, the attorneys would say, this is how much so-and-so charges an hour, this is how so much, you know. And when the clients called in, and they would ask how much, I understand that like they set the fees. I mean, the attorney said it's going to be $250 an hour or whatever. But sometimes there's gray areas, like they'll ask, well, if I'm going to go through like a divorce, or how much does this cost, how much does that cost? I always felt uncomfortable saying anything. I didn't know what we are and aren't allowed to address as far as fees are concerned.
So in that situation about setting fees, if the fees are set prior and you're not pulling some number out, but you're operating within fees that are already set, I think it's appropriate to tell them what the fees for that attorney are. However, if you feel uncomfortable, you go talk to your attorney, say, what should I tell them?
Like deposits, retainers, for instance. Each situation is going to be different. The attorney would often rely on me to suggest a deposit, a retainer.
I suggest you have a talk with your attorney about that.
I left for reasons like this.
Because that gets into the realm of you being in charge of that case, and that's not appropriate. So, yeah. That's,
What's tricky too nowadays with e-signatures, you know how you have the line, you just type slash, you know, Eric D. Babbitt slash, and that's his e-signature. So when you're preparing documents, my attorney's always like, just get it all ready and then I'll review it. And I know some people in the office will not sign, they want him to go into that Word document and actually do that. And yet the guy I work for says, I don't have time, get it all ready, I'll look at it and I'll tell you if it's okay to file. But I just feel really uncomfortable saying, to me, the e-signature is like I'm signing for it.
and I'm gonna address this generally, and I should have been more general, because I don't wanna give like specific advice for certain circumstances, which that was my bad, but, so generally, when it comes to signatures and things like that, there's not a black line, this is the rule. There has been a case that I know about where an attorney, was found to have violated a rule because the paralegal e-signed for that attorney after giving it to the attorney to review. The attorney tried to put on the paralegal saying, well, she signed for me. And the court said, no, you were the one that was supposed to review it, and it's your signature, ultimately. So you can determine your level of comfort. E-signatures are not outlawed. It is up to the attorney to review the documents that have their signature on it. And if they're willing to just say, prepare it and then let me review it, that's their prerogative. If they want to sign it themselves, that's their prerogative. Where you get into problems is when they don't review it prior to submitting it. Because then that's a whole other issue.
I'm sorry, I need to excuse myself. I'm
No, you're-
sorry.
Do you have any parting words for us?
No. Have a good day.
Any other questions?
I
Yes.
got one. How many like complaints do you guys deal with per year, say, with Utah attorneys?
Sure. So, for the year ending June 2018, so our fiscal year goes from July to June. And this year's report, I don't know the numbers on yet. So for the year ending June 2018, we had around 1,600 complaints come in. Out of all of those, by the time you get to disbarment, you have like 2 disbarments. Because 800-ish get dismissed. The rest of them go through various stages. So it's a fair number of complaints that come in. There are 6 attorneys in the office. 3 of them deal with the cases in district court once they get to that level. 2 of us deal strictly with the ones up to the screening panel, so through the initial investigation. And then 1 deals with the ones in the screening panel, but also does our appeals in district court if attorneys don't like the outcome. So yeah, so we divide those up between all of us. Yeah.
Are the records open?
Which records?
The records investigated by your office? There's.
For the most part, no.
Okay.
The only records that are public reprimands and anything that happens in district court. So if it's determined to go to district court, then it's a public case. Public reprimands, just because they're published in the Bar Journal. All of our investigations that take place are confidential. We don't reveal them, except under certain circumstances, which you would never be a part of, I'm sorry. But, and then, yeah, so you can certainly ask if an attorney has had public discipline, but it's hard to get records on the private discipline or anything like that.
Just was curious because there was an attorney who was, I'm familiar with, who had represented himself to be a police officer. And, yeah, wonder what happened with that case.
You can go back through the Bar Journal and
Uh-huh.
see if you find any facts relevant to them. No, we do that mostly because a lot of bar complaints, like I said, a lot of them get dismissed and are frivolous, and
You
we
don't want
keep
to hurt a reputation. if it's-
exactly. We keep records simply because we need to, but we don't.
So in that instance, you could open up a case because it's, hit the media. And so your office could open a case based on that.
Yeah, and we'll do that periodically. We'll see something in the media that has happened with an attorney. And there have been some high profile ones, which I'm sure you all have heard about, that we get in our office. We do. And some of them turn out to be not rules, no violated rules, which is always hard, I think, for the public to understand.
Right.
But it's a different standard than the public standard. A lot of the public just wants attorneys to be arrested.
Really want to get even.
I sadly had to tell a complainant the other day that we can't perform citizens arrests. He was not happy with me. It's like, well, I'm gonna come there and do it myself. I was like, go for it. Okay, any other questions or comments? Okay, got done a little early, but I appreciate the opportunity to talk to you. I hope you learned something. Thank you.